This is a quick overview of the Companies Act 2014. The new Companies Act 2014 has over 1,400 sections, but in the main, many of those sections will not apply to you, particularly if you are in a small private business. There is a number of novel changes, including the creation of new types of companies and new rights and obligations for members and officers. When is this going to affect you? The answer is that from the 1st of June 2015, the Companies Act will be in force. It will apply from that date to all limited companies, companies limited by guarantee, and unlimited companies. Immediate steps to take. It is important for any owner, officer, or shareholder of a company to review their existing company structure, whether you have a group of companies or a single corporate entity. The first review will be the existing memorandum and articles of association. These will largely be changed by the new Act and may require revision both to protect your own interests and to avail of some of the more relaxed and novel provisions of the new Act. Is a change of name required? If your company is a private company limited by shares, there will be no need to change the name. If it is intended that you will become one of the new types of company, such as a designated activity company, then a change of name will be required during the transition period, which runs from the 1st of June 2015 until the end of November 2016. If you are a company limited by guarantee, then you will also have to change your name and adopt to the other transition provisions, and more information about this from Lee & Sherlock solicitors. There are default provisions which will apply after an 18-month transition period, and these will include that a company limited by shares will be deemed to be a limited company under the new model form of the Companies Act 2014. A new constitution will be imposed, which will include the existing memorandum and articles of association. If you are a company that wishes to change its designation to a designated activity company, then there's a 15-month period within which you should complete the transition arrangements. One of the novel provisions of the 2014 Act is the possibility to have one director in certain circumstances. This recognises the overwhelming majority of companies which are small private limited companies and which are usually operated by one person. During the transition period, it is not possible to have one director only unless you have completed the transition to the new model form company. If you remain a company limited by guarantee, or if you redesignate to a designated activity company, you will still require a minimum of 2 directors. The main changes which affect directors include, for the first time, a list of specific duties imposed by the legislation itself. Many of these duties have evolved over the years from court decisions, and while they have been imposed as a matter of law, they are now clearly set out for both directors and for persons who deal with directors, including stakeholders in a business, such as shareholders and people who contract with the company. There are 8 specific statutory duties. In addition, the Act imposes many duties throughout its provisions dealing with all sorts of interaction that the company may have between the company and its members, the company and its other directors, and the company and external parties. Among the specific duties which are set out in the Act include a general provision that directors must ensure that the company complies with the Company Acts. There's a duty to ensure that the company secretary is a suitably qualified person. There are additional duties in relation to declarations to be signed for particular transactions. There are further duties and increased obligations in relation to the financial statements of a company, which includes the accounts, the actual financial information, and the reports which have to be prepared and submitted to its members and to the company's registration office. there is some relaxation in the duty of directors to disclose interests when there is a very small 1% interest in a contract or a company. For small private companies, there are many transactions which are commonplace, but which have been prohibited and remain to be restricted activities under the new Act. The most common transaction, which is a restricted activity, is a loan to a director or a connected person. Connected person has a particular legal definition, and it includes the spouse of a director. There is a new summary approval procedure which will replace all previous procedures which were called whitewash procedures. Whitewash procedures were brought in to enable companies deal with specific transactions where there was full disclosure to the members and an informed decision could be taken by the company. Many of these whitewash procedures are there to prevent directors taking a commercial advantage of a company of which they are a director. The new summary approval procedure involved a special resolution and a declaration signed by the directors, and has particular strict time limits in relation to the filing of the necessary documents. The new Act has enabled small companies adopt a more modern approach to general governance. And examples of this are the opportunity for limited companies subject to other rules to be able to proceed without having to hold a formal annual general meeting. That is a particular advantage in a small single member company or a company where there is a small number of shareholders and they are all involved in the business and have decision-making powers. It is now possible for majority decisions to be made in writing, and this is an important benefit which will require people to look into the existing memorandum and articles of association. Where a transition has occurred adopting the default existing memorandum and articles of association, a company may lose out on the benefit of being able to make majority decisions in writing without the necessity for formal meetings. There will still be the necessity for formal meetings for any resolution to remove a director or an auditor. There are very strict filing time limits for these type of resolutions, and if an urgent decision is required, a meeting may be necessary because there's a lead-in time during which the resolution cannot be effective. A new default position allows a board of directors to make decisions in writing, and in certain circumstances, majority decisions to be made in writing. Directors' board meetings can be held by teleconference and even by email exchange where there are sufficient safeguards to ensure the directors have full information. Financial statements is a new definition in the Companies Act which includes financial accounts and the reports and other information which must be furnished to the members and in many cases filed with the Companies Registration Office. The new Act imposes increased obligations for directors to declare and stand over the information contained in the financial statements. Directors must also declare that the auditors have been given all information which they require. There are a number of changes to the audit exemption which will benefit many people involved in small businesses. There are definitions for a small company or a medium company, and to claim or avail of an audit exemption, the company needs to satisfy only 2 out of 3 criteria, whereas in the past it has been necessary to fulfill all 3 criteria. A company limited by guarantee can now avail of an audit exemption in certain circumstances. A breach of the Companies Act can be an offence, and there are numerous offences listed in the legislation. These have now been summarised into 4 categories, and the 4 categories include prison sentences as possible punishment for 3 out of the 4 categories. A category 4 offence will only attract a fine currently up to a maximum of €5,000. There are sample charts to indicate examples of what constitutes what offence. The creation and registration of a charge or mortgage by a company is going to change from the 1st of June 2015. For many small companies, you may notice no difference other than a change in the documentation produced by a lender. But it is important that you understand and are aware of the nature of the procedures and the consequences. There is now the facility for a two-step procedure to obtain priority by registering the intention to create a charge. Most companies are involved in business with a view to obtaining a profit. And of course, with any venture, there is a risk, and it's important to realize what happens if something goes wrong. The main areas of enforcement for companies in difficulty include the appointment of a receiver, where there is a charge on the assets of the company, the appointment of an examiner, where a company is insolvent but believes it has a reasonable prospect of survival, and liquidation, whether by the members, the creditors, or by a court order. The main changes in relation to insolvency matters are the requirement for liquidators and receivers to be qualified. If a company goes into liquidation, the default position, which requires a liquidator to take a case to the court seeking restriction of directors, remains. This default position means that unless the Director of Corporate Enforcement relieves the liquidator, a court application is required. Under the new Act, the situation is somewhat relaxed in that it permits an undertaking to be given in certain circumstances to the Director of Corporate Enforcement, and this could avoid litigation and avoid unnecessary costs. A summary of 6 new points in relation to this Act are: 1. Majority decisions can be made in writing. 2. There's a new provision which permits a company to correct previously defective financial statements. 3. The removal of a requirement that every reduction in share capital must be made by court application. 4. A company can re-register so that a limited company can become a company limited by a guarantee, or indeed a company limited by guarantee can change to a limited company. 5. New thresholds and relaxed definitions to avail of the auditor's exemption, including an exemption for dormant companies. 6. The summary approval procedure, which provides a cure-all for many potential restricted activities for small and medium companies. Thank you for taking the time to view this presentation. We hope it has been of some use to you. If you have any query or wish to obtain some advice, please contact me at the details listed below. Thank you for watching.